a known trusted amendment. Senator Garrett, would you yield?
Will Senator Garrett yield?
Sure.
You're in order, Senator Boulton.
Thank you. Senator Garrett, you were giving examples of how the United States Supreme Court has talked about this being a right that is something that applies to individuals, and that we've had Supreme Court decisions that have been followed. And I know you're familiar with application of law and jurisprudence and stare decisis and the things that go with applying prior decisions to current decisions moving forward. So we have consistency in the law, correct?
Well, that's the way it's supposed to be, but unfortunately the courts don't always do that, as you well know, and we've had a lot of discussions about that, and that's the concern. When you have a 5-4 decision, that tells us that if there'd be a little change in that court, who knows what a new court might rule. So that's, and you understand that. I know you understand that very well.
Yeah, and I'm just clarifying again. So the 5-4 decision you're referring to, when was that?
It's 2002. It's been a few years ago.
Okay, so it's been fairly recent that we have reaffirmed that standard. So I would argue that it would not be something that's a dated decision, that it's a long time has passed and we don't know what the court was thinking or how it was interpreting language way back then, right?
Well, way back then, as far as I'm concerned, that's not necessarily way back then, but the point is, courts change their minds. You've got the living, breathing document. We had a discussion about that. And some courts don't go back and take the original language as it was written or stare decisis. They put their own views into the Constitution, and 4 judges were perfectly willing to do that back at the time of the Heller case.
And that decision has been followed, but I'm glad you mentioned the living, breathing document again, because I'm going to ask you, as someone who I believe you're probably more of an originalist interpretation of the Constitution person, I'm going to ask you, where does this strict scrutiny standard appear in the original document or in the long-standing traditions of court interpretation of constitutional standards?
This has been a very interesting discussion here, these last 2 discussions, and you're wanting to imply that the language is different in the U.S. Constitution and in Senator Zahn's resolution, and there is some language that is different, but let's look at this. Here's the meat of the Second Amendment. When you take out the preamble that talks about a well-regulated militia, here's what it says. The right of the people to keep and bear arms shall not be infringed, right? That's the U.S. Constitution. Senator Zahn's proposal. The right of the people to keep and bear arms shall not be infringed. Word for word, exactly the same language. That's the meat of both amendments, or both of these amendments from the U.S. Constitution and Senator Zahn's resolution. That's what they say. That's what the right they're protecting. The strict scrutiny, that's just how the courts are to interpret it. That's not the right that's being bestowed on the people. The right is exactly the same words. Exactly.
So I'm going to ask you then, in your opinion, as we develop legislative history here, do you believe that this language is the exact same and confers no greater rights than the federal amendment to the Constitution?
I just said the words are exactly the same words, once you take out the preamble in the federal Constitution.
And that's why I want you to clarify what your position is. I want to know, if we delete part of the federal amendment and add a new part, does it have the same meaning and effect, a greater meaning and effect, or a lesser meaning and effect? Are we creating a greater state right than the federal right? Are we creating the same right or a lesser right, Senator Garrett?
The language is exactly the same, word for word. Exactly. There's not even one word that's different in the right that's being bestowed on the people. Word for word, the same thing.
So you believe this is the exact same right as the federal right?
I believe the words of the proposal are the same. Now, how some court may interpret it or whatever, you can't predict that. That's why we get concerned about, and that's why we've got the language in here about strict scrutiny. We're trying to make sure the courts adhere to the meaning of these constitutional provisions that was intended by us here as we amend our Constitution. We want the courts to go along with the intent of the amendments. And the wording
that's
is
the whole
same.
point, Senator Garrett. We want to know what our intent is as we ask the court to apply with strict scrutiny the exact intent of the language. That's why it's important that we don't say, well, part of the language is the same, that we actually debate and discuss what this means. Is this the same right? Is this a greater right? Is this a lesser right? Iowans deserve a straight answer to that question. Are we changing the Iowa Constitution to a greater extent, lesser extent, or the same extent with this language? It is unfair to the people of Iowa to say, hey, let's go amend the Constitution, but not tell them what the intent of the amendment is. We need a straight answer to this. We need a straight answer in this debate, an honest discussion of what this means. And the question must be, when we start applying strict scrutiny, the question must be, what does this language do in our state to carry out other regulations? Senator Garrett, does this language, with a strict scrutiny standard, with some of the same language, some missing language, some added language as the federal U.S. constitutional amendment, does this language mean we can still have permitting processes in Iowa?
Senator Boulton, the strict scrutiny provision is to try to protect the meaning of the provision that says the people's right to keep and bear arms shall not be infringed. Based on our experience over the years, we have learned that not everyone will take that language and apply it, the plain meaning of the wording. So in order to try to protect ourselves and make our meaning clearer, that provision is added for guidance, hopefully that a court will follow in the future. But the right that we're protecting, I've said this over and over, and you don't like to accept it, is exactly the same wording. We're just trying, based on past experience, to protect that wording to the greatest extent as we can in the future, in future court rulings.
Well, if it's the same right and the same intent, what's the harm in replicating it with the same language that Senator Bisignano has offered?
Well, I've just explained that. We have learned over the years that people want to take the well-regulated militia preamble and they want to make that part of the substance of the right.
So you do want to change the federal amendment and how it applies here?
I just explained that.
I think you did. Thank you, Senator.
That it's the wording of the meat of the language, not the preamble, that we're concerned about.
Thank you, Senator. I think this discussion really embodies the importance and gravity of what we are talking about here.